Hi, this is Chris Eskew. I am a criminal defense attorney here at Eskew Law. We get asked a lot about restraining orders. In Indiana, a restraining order can fall under one of two areas of law. One is criminal law, which is a no contact order, and the other is a protective order, which falls under civil law. Under the criminal law, a no contact order is typically part of a release or part of a bond to be out while your case is pending. It can also be a condition of probation. In either circumstance, we get asked a lot if so-and-so is contacting me or they're messaging me and they want to talk or they're coming to my house. That no contact order and term of probation is very strictly a one-way street. They will not get in trouble for that. However, if you have the order against you, you certainly can. You can have your bond revoked or probation violated. So it's completely up to the defendant to do that. Now, a prosecutor may look at the circumstances in which the contact occurred. A judge may look at that as well when determining what sanctions to order and may just warn you and remind you that's your responsibility and it's a court order you're violating and it's not necessarily the witness's wishes. But again, it is completely on the defendant to follow that. The other area of law is that falls under the civil law code. And I've brought in attorney Yasmin to talk about that.
Yeah, so with a protective order, Chris is absolutely right. It's completely different in that it's a civil matter, but it can have a lot of the same kinds of consequences and implications that a no contact order would have. The reason why I'm talking about it today is because there's a lot of overlap sometimes with family law and protective orders in that a party might file for a protective order against their co-parent or against an ex-girlfriend or boyfriend, against a spouse, former spouse. So I do see a lot of those come across my desk. And as Chris said, with a no contact order, the effect of a protective order is very similar. If you are the respondent, if you're the person against whom it's filed, you'll want to be very careful that you are not violating that protective order. You could face some pretty bad consequences if you do. That's any kind of contact, direct, face-to-face or over the phone, text message, phone call, or indirect, which, if you give a message to your best friend and say, give it to that person, that could be seen as a form of indirect contact. And so you'll want to make sure that you understand when a protective order is issued, whether it's ex parte, meaning without a hearing on its face, or after a hearing, if the protective order has been issued, you do not want to violate that. And sometimes in the family law sphere, we can see that there's a carve out for parenting time in these protective orders. That might be where they're against, two parents, but those parents, even if they're not supposed to have contact with each other, or the respondent's not supposed to have contact with the petitioner, they still have a child and still need to be able to talk about some very basic issues. So I think it's important that if you're facing that sort of thing, you speak with an attorney who's familiar with protective orders and no contact orders, so you get the best information you can.
As Yasmin said, there are consequences to violating both, and that could be a charge of invasion of privacy. Also, you don't want to upset the judge who may be making rulings in your case.
Yeah.
And as she said, either way, make sure to contact an attorney. If you have any questions, contact us at Eskew Law on our website or our blog.